Thank you, Jenna. Good afternoon, students. Welcome and thank you for being here. I'm looking forward to your presentation today. I am Caitlin Johnston. I'm joining you from Manhattan, New York City, and I am a We the People alum. I did it in Indiana when I was growing up. Judge Murphy, will you introduce yourself, please?
Yes, I'm Ed Murphy. I'm a Superior Court judge in Tacoma, Washington, and congratulations on being here at the Nationals.
Judge Volpe, you're on mute.
Yes, welcome team. I am Edward Volpe. I'm an attorney from Denver, Colorado. I look forward to hearing your presentation today.
Great. Students, would you introduce yourselves and your teacher, please?
Yes. Hi, we're Unit 5 from Maine South High School. Our esteemed coaches are Andrew Tranquil and Kevin C. Hansen. I'm Matthew Coyle.
I'm Jack Koziaris.
I'm Catherine Cernell.
And I'm Amalia Lascaris. Thank you for having us here today.
Excellent. Nice to meet you all. Okay, I'm going to read the question all the way through. I think you know that it's question 1. When I stop talking, you can begin and that will start the clock. Okay. All right. A result of the decision in Wisconsin v. Yoder is that any parent or guardian can refuse to let their child go to school beyond the 8th grade or learn about a subject by saying it's against their religious beliefs. Do you agree or disagree with the result of the decision? Why or why not? What words, if any, are found in the US Constitution or in state constitutions that protect the right to an education? And how have courts balanced religious beliefs with other rights? You may begin.
As Lyndon B. Johnson once said, nothing matters more to the future of our country if we lack the brainpower to build world peace. For freedom is fragile if citizens are ignorant. In this quote, Johnson argues that a well-educated populace is paramount to the success of any democratic nation.
We agree with the importance of secondary education, but disagree with the court's ruling. Secondary education as a whole does not violate a child's religious liberty. However, after the 8th grade, children should be allowed to opt out of certain topics and subjects.
Secondary education is essential for all kids and does not violate a child's religious liberty. We disagree with the court's ruling striking down a law requiring education up to 16. In order for a law to infringe on free exercise of religion, it needs to pass strict scrutiny. The law in question does.
The government possesses a compelling state interest, as seen through a study done by Global Citizen, which states over 40 years, equitable access to quality education can help raise its GDP per capita by 23%.
This law operates in the least restrictive means possible, as obligating children to complete a further 2 years of education does not have a large impact on a child's ability to freely practice their religion.
In tandem with the Lemon test, the application of this law is constitutional. The test shows the law does not establish secularism and is therefore not a violation of Amish culture.
We agree with Justice Douglas's dissent in Wisconsin v. Yoder that while the parents normally speak for the entire family, the education of the child is a matter on which the child will often have decided views.
The First Amendment's Free Exercise Clause protects citizens' rights to practice their religion, while the Establishment Clause prohibits the government from supporting religious activities.
Sherber v. Verner established the government can restrict the free exercise rights of individuals only if they survive strict scrutiny.
A Religious Freedom Restoration Act, both on the state and national level, provide even stricter scrutiny for courts stating that the government may not burden a person's free exercise of religion unless it interferes on a federal level. The Do No Harm Act aims to clarify the original intent of RFRAs.
It is a child's right to be able to remove themselves from any subject.
The right to an education is not explicitly stated in the Constitution. However, the basis for it has been derived from Brown v. Board of Education's ruling, which states the 14th Amendment requires that all kids be given equal educational opportunity.
In addition, the 9th and 10th Amendments grant states the right to incorporate the right to education into their own constitutions. Serrano v. Priest's ruling recognized education as a right under California's Constitution.
Rose v. Council for Better Education further defined educational guidelines, which were then adopted by 22 states. Illinois state constitution states in Article 10 that the state shall provide for an efficient system of high-quality public educational institutions through the secondary level.
We cannot deprive children of this high-quality education. Secondary education needs to be required until the age of 16.
The Supreme Court has frequently ruled in favor of civil rights, taking precedence over religious beliefs. In Obergefell v. Hodges, the Supreme Court ruled that the government must recognize the marriage of same-sex couples.
After this case, Justice Kennedy claimed that religions may continue to advocate that same-sex marriage should not be condoned. However, through this case, the court values this civil right over religious beliefs.
Following this trend, the court ruled in favor of abortion in Roe v. Wade, arguing it is for the common good. There should be no different with the right to education for Amish children.
Tora Bontrager, the founder of the Amish Heritage Foundation, believes by not being educated, we Amish don't have the ability to protest Wisconsin v. Yoder. Only some of us ever exit the community, even less get a college degree.
As John F. Kennedy once said, let us think of education as the means of developing our greatest abilities, because in each of us, there is a private hope and dream, which fulfilled can be translated into the greater strength of the nation.
Wisconsin v. Yoder undermined the idea that education is key for the growth of children. Secondary education as a whole should not be foregone on the basis of religion. However, certain secular subjects can be opted out to due to religious beliefs. Thank you. We are now open for questions.
Great, thank you. Please put your notes away. And I will start. You mentioned the Lemon test, and I'd like to talk a little bit more about how we analyze laws that have an impact on religious beliefs. And specifically, the panel seemed to suggest that your preferred cutoff was 16. What's so special about those extra 2 years, and how do you arrive at your conclusion there?
Well, we believe that 16 is crucial because from going from 14 to 16, children's brains are both developing and they're gaining more responsibility. And we believe 16 is kind of the age where you are able to drive, get a part-time job, and with it, you kind of see a raise in responsibility and your mind developing further.
In addition, a study by Stanford School of Medicine found that from late adolescence, so ages 14 to 16, children begin to develop critical thinking skills and begin to see their own place in the world. And we believe that education during this time is crucial so they can develop these critical skills that'll help them in their adult lives.
Adding on to my colleague, former psychologist Paget had a theory of the cognitive development theory. And at this stage, at the formal operational level, children in late adolescence form opposing views and deductive reasoning. And at this age, they can then use this reasoning to help form their own religious beliefs.
Can a school require that students be vaccinated against the coronavirus against a parent's religious beliefs before the child is allowed to return to school?
Well, we believe that, yes, they should be required to get vaccinated. We can kind of see this as sort of a common good argument, whereas, yes, they are giving up their right or freedom of religion, but for this case where the common good outweighs that of a person's individual rights, it is needed. We've seen this in the past too with the Boston bombing, where people gave up their right to privacy for the common good.
And in addition, in Jacobson v. Massachusetts, the Supreme Court ruled that the government of Massachusetts was allowed and upheld their ability to fine people who did not get the mandated smallpox vaccine, following a similar classical Republican argument as we can make here with the coronavirus.
However, some religions such as Catholicism do have concerns from vaccines that derive from aborted human fetuses. However, the Pfizer and Moderna vaccines both are using fetal cell lines rather than fetal tissue. So it's a much different concern. And I would agree with my colleagues that the common good does outweigh their personal liberties in this case.
And adding on to my colleague, we have seen that the courts have overruled for this common good argument. In the court case, Matter of Erickson v. Dilgard, we have seen that a parent did refuse a blood transfusion for their child on religious grounds. However, the court did overrule this and said that for the child's sake and safety of their health, they must require this blood transfusion.
You have talked about the importance of education for our economy and for the growth of our country. You gave us the Kennedy quote and so forth and so on. Does that extend to those who are not citizens? In other words, could a government ban the attendance at public schools of illegal alien children?
No, in the case of Rodriguez, they defined that education is under a property right, and you need education to make a means of living. So therefore, you are still allowing illegal immigrants then to go to school and get that education?
Anyone else? Back to you, Caitlin.
Sure. Okay, so back to a parent's religious beliefs vis-a-vis students' rights. If a religious sect believes in marrying their young girls who are under the age of 16, let's say, and forcing arranged marriages and childbirth soon after that, how do you analyze that? How do you strike a balance between the child's rights and the parents?
Well, as seen in Employment Division v. Smith, the Supreme Court ruled that the government, the government is free to regulate a certain echelon of society, that they can regulate this, and a person's religious beliefs does not excuse them from following this law. In that case, it was drug use of peyote in religious ceremonies, but that could also be seen as they are free to regulate the age of consent in their states, and such laws like this, that a person's religious views would not excuse them from these laws.
In addition, in the UN Convention's rights of the child, some rights are outlined that the child does have separate from their parent. For example, in Article 24, the right to education is defined, as well as many other rights.
In addition to this, in the CRC, it does state in Article 14 that a child has the right to practice their freedom of religion in respect of the direction of that parents. So we see a differentiation of the children's rights and the parents' rights.
It's been almost 50 years since the Yoder decision was reached. Do you have any thoughts or opinions as to why that hasn't been overturned? And do you think that it would be decided the same way today?
I believe this issue has turned into something larger. 50 years ago, people found this case as, and we're just kind of in support of the Amish, and they didn't think it was going to go anywhere beyond educational rights. But I believe now people are looking towards Wisconsin for more larger issues revolving religion, such as the COVID vaccine in schools. So I believe, yes, it would be ruled a little bit differently if ruled today.
And the Yoder decision did create a sort of dangerous precedent, as in the decision Hobby Lobby or Burwell v. Hobby Lobby, they used similar rationale to give corporate entities religious rights, and they also allowed them to prevent people from receiving certain critical components of their healthcare because of their religious beliefs. And that case relied heavily on the logic used in Wisconsin v. Yoder, which was more of a strict scrutiny argument, as opposed to many religious cases which applied a neutrality argument.
You mentioned employment division, or Smith versus employment division. Has the court ever ruled that a religious group may use a prohibited substance if it has been historically used in their religious ceremonies?
Yes, they have. In Gonzalez v. Ocentro, they said that the community could use the drugs because the UDV was not shown to be dangerous enough.
Jenna, do we have a time check? Yeah, that's what I thought. Okay, great job, everyone. You can take a breath, sigh of relief. We'll go around with some feedback. I thought you did an absolutely superb job. You packed a lot into your prepared marks. I was writing furiously. My first follow-up question was going to be to try and tease out whether you knew the lemon case, but you did that in your prepared remarks and the lemon test, right? When I went back to it though, I was trying to get you to tell me about to go back to the common good principle for why you chose 16. And you gave me a ton of really interesting policy citations, but you didn't actually, or if you did, I missed it, tie it back to that principle for how you were analyzing it. That said, like the amount of subject matter that you all have command over in terms of case law, other policy research was stupendous. And there were so many things I wanted to revisit. The Catholicism objection that you lobbed in there about the vaccines, just really excellent, thought-provoking follow-up. I would have loved to have stayed and talked to you all day. So good job.
Yes, very well done. I too was trying to write some notes and keeping up with the cases. And you may have seen our heads nod when you'd mentioned some certain cases, because there were some issues that we had talked about that we were aware of certain Supreme Court cases that have been decided, and you were ticking off just about every one of them when you got to that particular subject matter. So that was very impressive. And I know you have only 4 minutes to start with. You were going very fast. You actually had a little bit of time left. I'm not sure how much time. It's kind of hard for us as judges to kind of keep up with you sometimes. We're kind of grabbing on and trying to hang on. But that's because you really had a mastery of the subject matter, and it was very impressive. So well done. You should be very proud of yourselves, and good luck as you move forward.
I would echo the comments of my fellow judges. I think a certain amount of congratulations must go to your teacher with regard to how well you have been prepared for this competition. I was very impressed with the balance of your panel. You all contributed equally and very enthusiastically with regard to the questions we asked you, which were tough questions. I thought you did a good job of covering the whole range of Supreme Court cases. You came up with Sherbert v. Verner with regard to firing an employee based upon their religious beliefs, didn't want to work on Saturdays. I thought that was excellent. In response to one of my questions, you came up with Gonzalez v. O Centro. I was very surprised you were able to come up with that. The use of peyote. In that case, they cited the Religious Freedom Restoration Act that Congress had passed. And you continued to talk about the private employer problems with Burwell. You came up with the vaccine cases of Jacobson, and you mentioned that that was for the common good. You came up with some other interesting cases about common good, which I thought was an interesting twist on your presentation here. You came up with Obergefell v. Hodges and Roe v. Wade, which basically talked about implied rights as opposed to guaranteed rights. But nonetheless, you did a good job of explaining those. You did cite the Lemon case, and you came up with the Do No Harm Act. I was very, very surprised by that. But anyway, you went on to give us your personal beliefs about how important the last 2 years are to a student's formal education, and how good education is for both the student and for our economy. You also came up with the 10th Amendment, which reserves all of the rights to the states and to the people respectively, and how the individual states have guaranteed an education to their citizens. Virtually every single state has a provision in their constitution that guarantees the right of an education and establishes the funding therefore. But I thought you did a very good job of coming up with your attitude, which, you're asked why or why not, do you agree? And you were very clearly of the opinion you did not necessarily agree with Yoder. And I'm not sure Yoder would be decided the same way today, but nonetheless, it was decided the way it was at the time. But again, congratulations on your hard work. It is a credit to this program that people your age can do what you just did. And again, congratulations to your teacher. I have nothing but compliments for what you have done here today.
Thank you very much for all your feedback.
Yes.
It's very appreciated.